Hello, everyone, and welcome to AWCI's webinar, Construction Contract and Its Risk. I'm Tao Nguyen, AWCI's Education Program Manager. At this time, I'd like to introduce our presenters. Mike Madigan is the Director and Chair of Kegler, Brownhill, and Ritter. He focuses his practice primarily in the areas of construction law and litigation, advising clients on mechanics liens, collections, and other issues in the construction industry. Presenting with him today is Shawn Burnum. Shawn is the Senior VP at PCI. With over 30 years in the construction industry, Shawn is about providing leadership, implementing strategic initiatives, and nurturing and development of the company's talented teams to ensure top-notch construction services for their clients. So welcome, Mike and Shawn.
All right, thank you so much for that introduction, and welcome everybody to AWCI's webinar on contract provisions. Hopefully we can provide you with some useful information in a way that doesn't get us too bogged down into the dryness of contract provisions. So with that, let's get started. A little bit about myself. Many of you may recognize me as AWCI's General Counsel. I oftentimes will say grace at the beginning of the meetings in the form of the antitrust statement policy. But back here in Columbus, Ohio, where I'm based out of, I practice construction law. I've been doing that for about 20 years. Prior to that, I worked at Whiting Turner for 5 years before going to law school. And then prior to that, I went to the University of Dayton and obtained a civil engineering degree. So you may ask, what does 20 years of practicing law, working in construction look like? Well, here you go. Now, Shawn, maybe you want to, if you want to introduce a little bit, talk a little bit more about yourself. You have a full head of hair, so I compliment you for that.
My life must be easier, right? But I got a lot of gray hair. It's gone gray really fast over the last few years. But hey, I also have been in the industry for over 30 years. Makes me feel old. But I've worked for organizations that have allowed me to have experience really through most of the country. I always tease that I've worked in about every state except for California, Oregon, and Washington. And so the amount of teams I've worked with and the dynamics of those teams has been a lot of fun. My degree is construction management, and then I have a master's degree in organizational management back when you actually went to school at the University of Phoenix versus online systems now. So that's a little bit about my experience. Today, I help lead our company here in really, I call it the Mississippi River to the border of California. So.
Thanks, Shawn. And you know, Shawn was president of AWCI from 2021 to 2022. So we again thank Shawn for his service to AWCI. So in terms of the agenda, you know, we could spend days talking about contract provisions, but we really wanted to try and focus it down onto some key terms in this hour. And you can see them laid out there. The payment terms, we'll talk about pay if paid, pay when paid. We'll talk about delay, schedule provisions, design obligations, insurance, and then claims and dispute resolution and how that process works and things to be mindful of. Throughout the presentation, if you have a question, we ask that you send it to Anne-Marie, and Anne-Marie can chime in when the time is right. And if you have questions afterwards, feel free again to contact AWCI, Anne-Marie, or myself or Shawn. Happy to help to the extent we can. Now, I practice law here in Ohio, so the information I'm giving you is general in nature. Obviously, I have an Ohio perspective. If you really wanted to drill down on it further in terms of the specifics, I asked we'd have to get you, set up with an attorney from your state, but I think the general principles are going to be sound throughout wherever you're working. So with that, let's start with the payment terms. And I use the term contingent payment terms because basically what that means is, well, you may or may not get paid depending on what happens upstream, and in a lot of cases, things that you can't control. So I think a lot of people probably have heard the payment provision, pay if paid. And the way you can identify that is the key term condition precedent. And if you go in and you type in the term condition precedent on your subcontracts, especially with your major CMs, the ones that are, have a national practice, you'll see that term condition precedent light up like a Christmas tree. And here's an example of a payment provision, of a pay if paid provision, and this one's from Turner. And I'll use provisions throughout this webinar from other CMs, including Whiting, Turner, Gilbane, Hansel Phelps, just so that we're not picking on anybody. But this is what's in the subcontracts that probably many of you are operating under. So here you can see the term condition precedent, and essentially what that means is if the CM, Turner in this case, or Gilbane, or whoever it may be, if they don't get paid, there's no obligation to pay you, period, the end. In a lot of states, that's enforceable. In some states, such as New York, they're not enforceable, but here in Ohio, they are. And I would tell you, look, if you're under contract with a pay if paid provision, you need to take it seriously. As I said, throughout the subcontract, you'll see that condition precedent throughout. You'll see it at final payment, and you'll also see it, in the section of the subcontract where it talks about extension and getting paid for those extension costs. And essentially, what it says right here is, look, the CM has no obligation to pay you unless they get those delay costs from the owner. And as I said, that's oftentimes in most contracts these days. Now, what that represents legally is it's a significant hurdle if the case goes to litigation, because what can happen is a CM can submit a motion to the court and attach an affidavit and says, well, we didn't get paid, so this trade contractor's $2 million inefficiency claim goes nowhere because we didn't get paid by the owner, period, the end. They can file that very early on in the process. And what that does is it really puts a cloud over the entire claim. A court could rule on that and knock it all out very early on, or maybe even on the eve of trial. So it really puts the trade contractor in between a rock and a hard place. And oftentimes what will happen is the CM will say, hey, you have a pay if paid provision. We're going to file this motion, but here's a number, here's an offer that you can take that's pennies on the dollar. And the trade contractor has the choice of either accepting that offer or rolling the dice that they can get through this initial hurdle and survive, and ultimately have a trial on the merits. So Shawn, do you have any comments? I'm sure you've looked at your fair share of pay if paid provisions. Any comments on how you are accustomed to dealing with them?
Well, a lot of times in a variety of these, what we call killer clauses, and this one would be one of the identifiable killer clauses that our team looks at, is understanding a couple of things. First of all, you're likely, if you have a rigid contract, and since we're looking at Turner being one of them, they're likely not going to remove language that is like that in their contract. But you can possibly get some understanding of what that means. What we typically do is write addendums to contracts with further explanation or notations or whatever, and or clarifications on some of these clauses. And one of the things to be mindful of is understanding Turner to owner, or contractors, or CM to owner's contract as well. It's okay to do credit checks on a variety of different people and other things too, to see how the money and how the job is being funded, and try to exercise as much caution as possible, and consider all of that when you're making those decisions.
Right. And to me, as I look at it, with the pay if paid provision, you really need to do your due diligence on the owner and the project team.
Right.
Turner, Gilbane, Hansel Phelps, they have sophisticated project teams that can they can do complicated projects. Not every team though can pull it off. And so you need to weigh that as you're providing pricing. Does this team and does this owner, have the wherewithal to pull this project off? Because if not, I could be left holding the bag.
Yeah, and the examples that I'm thinking of in my head where we've really kind of shied away from opportunities is when we know, hey, it's a startup company, or it's a company that may be on the fringe of some investment or some technology, or things in the news that you hear. And I'm going to pick on like a WeWorks, how they were struggling financially, or all those things. And they were continuing to do construction all across the country when there was a lot of questions about their viability. So all those things come into play.
Right. So, as Shawn mentioned, it's unlikely that they're going to change, the larger CM is going to change their pay if paid, but I've found that some local CMs will, and some alternatives is what I've just shown you is, okay, you've got the typical pay if pay, that we've just talked about. But then we say the subcontractor is not going to assume the risk of non-payment from the owner if it's because the contractor or their other subs, which oftentimes is the case. The owner hasn't paid is because it finished late, because of the CM, and maybe it's other trade contractors. So in that situation, this provision here isn't going to apply. Now, where it could apply in this scenario is if the owner were to go bankrupt. In that case, it's not necessarily the contractor, the CM, or another subcontractor's fault. In that case, the pay if paid would still apply. But to me, I think that's an easier thing to handle, where the risk of the owner going bankrupt or being insolvent, it's spread to everybody. We're all sharing in that risk, number one. And number two, if you're doing work for a public entity, let's say the state of Ohio, if you're doing work for Ohio State or wherever, the likelihood of the state going, financially insolvent is very, very low. And it may be, it's probably low if you're working for one of these major institutions like a hospital. So this is one way to try and deal with that risk.
And I will say those are some of the terms, because you're absolutely right, that a lot of these things are the clarifications that we would try to get into addendum, because we might not be successful in getting the language changed in the boilerplate agreement. And to your point, yes, we have a lot more success with smaller firms that we might have, relationships with, versus larger firms that stick to the language, and then, we'll use some of this language hopefully in an addendum for further clarification. One of the things that you're talking about was public works, and I would just caution those that, if there's a lot of times that there's a public works project, or one that would be, I'm going to pick on a school that says, hey, we're doing these dormitories that are basically a part of our university or school or whatever, but they're privately funded. So just because they have the name of a college, make sure you understand what, where the dollars are coming from.
Excuse me, and Mike, we do have a question that came in. Someone is asking, how often are you told that you can't adjust the contractual language, and how do you get around that? They're asking this because they hear that a lot, especially when they're dealing with the bigger GCs.
I would say if you're dealing with a top 100 ENR, CM, something like that, it's going to be very, very rare that you're going to be able to have any real change to their base boilerplate. And I just think that that's something that you have to recognize as you're pricing the work. And like I said, you've got to price the work based on their project team, based on your risk assessment, and what you think of the owner's ability to pay.
And to that point, I think hopefully everybody's proposal says, hey, we're providing a proposal, here's our pricing, inclusions, exclusions. And one of the things on there that you're clarifying is, hey, that we will get to terms, so that in the event you can't get to terms, then you're not held liable for a proposal. A little different, consult your bid bonds and all those things. But on a variety of major jobs that we price, that language is in there. And if we're having conversations that are sticking points, we can either price that back into the job, or we can clarify, and sometimes that helps as well.
So we've talked about the pay if paid and the risks that come with that. But we talked about some alternative language. But another way to skin the cat, or an additional way, is to make sure if you're going to agree to proceed with a pay if paid, negotiate the right to stop work. And here's a provision here from the AIA subcontract, where if you haven't gotten paid within 7 days from when you're supposed to get paid, upon additional 7 days, you can stop work. Now, oftentimes, again, looking at a Gilbane or a Whiting Turner or a Turner contract, they're not going to have the right to stop work. But there's probably a good chance that the right to stop work is going to be negotiated upstream with your Turner and your owner. And oftentimes that upstream contract is incorporated into your agreement. And it's a way, and if I was looking at a project for a trade contractor, I'd want to know, well, what's the right to stop work? And oftentimes you're going to find it upstream with the owner and the CM, and it's a way to shield or at least minimize your risk. Probably under this scenario, you'd be out 60 days. You submit a pay application for the month of March. It's due the end of April, so that's 60 days. You haven't gotten paid, well, then you provide the notice, probably start slowing things down, and then you can stop work. But you're probably looking at 60, 70 days of exposure there, but at least you have the right to stop work under a provision because you haven't been paid. The other provision I would look for and strike would be a waiver of lien rights. And I've identified here, this is one in Turner's contract where it explicitly says you're waiving your lien rights. They may say you're not permitted to file a lien, and that's not great, but it definitely gets to a higher level when it says you're expressly waiving the lien rights. And that's very harsh, especially when there's a pay if paid provision, because essentially what they're saying is look, you can't lien the owner's property even though he's not paying, which to me, puts a trade contractor in a very difficult situation. Now, to be fair, Turner has recognized that, and I've seen them also strike it. So it's one of those rare provisions where they will strike something in their contract. The other provision I look out for when it comes to payment is the right to set off for other projects. This is one from Hansel Phelps here, and there's another one here from Gilbane. Essentially, they can say, look, if you owe us on project A, we can turn around and pull that on project B, even though they have nothing to do with themselves. Again, that's very harsh. It's unusual that happens, but they have the contractual right to do that.
Yeah, we pretty much get the set-offs pulled out, and we had some success there. And my only comment on the mechanical liens is obviously every state has their own mechanical lien law. And so I would make sure that you understand whatever state you're working in or have projects in, that you understand the requirements of that state.
Mike, we do have one more question that came in. If maybe you and Shawn can explain the set off a little bit more, please.
So
I can give real life examples of how this works. You know, you get to the end of a job, and there's some disputes and things like that are unsettled, and they will, and I sound like I'm being negative here, but at times they can say, hey, if we don't get it from this job, we'll take it from that job. Or, hey, you know, there's a project that for whatever reason they're claiming that you're not supporting. Well, we'll take funds or liquidated damages or consequential damages from one and assign it to the other. And what our argument is there's plenty of provisions in this contract for dispute resolution, that you have every right to come after us. You guys usually do a really nice job. Our clients did a really nice job of making sure that there's a lot of risk points for us. And this just isn't one that we will agree to, because it's not necessary based on all the other provisions that you've written. And again, we've had some success there.
So the other contingent pay, or the other payment provision that you often see is a pay when paid. And that's what you see with the AIA documents, the consensus documents. And you can see here there's no condition precedent. And what I've highlighted is if the architect doesn't issue a certificate of payment, or the contractor does not receive payment for any cause which is not the fault of the subcontractor, the contractor shall pay the subcontractor on demand. And under this type of provision, the payment is to be made within a reasonable period of time. Now, we can debate, is that a reasonable period of time, 45 days, 60 days? But by the time it gets in front of a judge or an arbitrator, that reasonable period of time will have been over, and the CM or construction manager isn't going to be able to say, well, I didn't get paid. It's like, well, that's not a good enough excuse under this payment provision. And that's why you see it, common with the industry standard forms like AIA and consensus docs. So that's pay when paid versus pay if paid, where all your ducks are with the construction manager. So the next provision we want to talk about is delays. Time is money, especially on construction projects, especially in this environment. So when we look to see some delay provisions with certain subcontracts, the first one here is from Whiting Turner, and this one says the contractor shall have the right at any time to delay, and an extension of time is the sole and exclusive remedy, and the subcontractor shall have no right to seek any recovery from the contractor. And you can see one here from Gilbane. Again, it's the exclusive remedy. It's just going to be an extension of time. So, back to what Ben Franklin says, time is money. that's just not, that's a big risk for trade contractors to have to be on the job longer than what, they were told.
Yeah, and this is something that's really, I think, percolated over the last few years. And I don't know what you think, Michael, in terms of the growth of this type of language in agreements where they're really trying to limit the ability of a trade partner to go after and recoup any of the costs related to delays. And at one point in my career early on, they always publish schedules. They're less likely to publish schedules, project schedules, and incorporate those schedules into the contract documents because then, they just don't want to be held to that level of scrutiny. So many times the schedules are not part of the contracts. And then obviously they have language in there that they can adapt the schedules unilaterally at that point. So for the risk for us as a contractor, a subcontractor here is, as he pointed out, the cost of not only the extension, but your overhead expenses, what the damage is to the backlog and how your manpower is flowing through your company, how you're covering your costs, all those things. Maybe there's charges that you were going to offset on a job costing, those types of things that really can impact your business overall. And so having this language in there really limits your ability to recoup. So it can have a big impact, in particular jobs that may be out of your normal territory where you're having folks travel and increasing your overhead expenses. So just some thoughts.
Yeah. And again, the ramifications of this provision and maybe some ways that you could get some relief from it is going to be state specific. Here in Ohio, this provision here that says, look, if there's a delay caused by the contractor or the owner, this provision here that says all you get is an extension of time, that's not enforceable. You can't have a provision like this that limits or prevents a subcontractor from recovering its delay damages. Now we can argue about how to limit that, but you just can't have a provision in there that says all you get is an extension of time. You're not going to get any recovery. Here in Ohio, that's not enforceable. Now, what we just looked at is what's oftentimes in the subcontract. And again, you may find relief in terms of what's upstream between the CM and the owner. And here you can see is a provision from consensus docs. And here, I'm back up. It says if the contractor is delayed beyond the control of the contractor, shall be entitled to an extension. And then it also says through items A through D, the contractor shall be entitled to an equitable adjustment, so money. So kind of breaking it down, the contractor will get money for omissions by the owner, changes, things that essentially that the owner is creating, encountering a hazardous condition, delay by the owner. So you get time and money under this provision. Now, it goes on to say, okay, you could get an extension of time for transportation delays, not foreseeable, a labor dispute like a strike, epidemic. So like for COVID, this provision here would apply. So in this situation, which would include weather conditions, all you're going to get is time. You're not going to get any money, but that to me seems fair because oftentimes no one can control what's here in red, whereas in the green, it's the owner that can control that. And if the owner delays the project, well, then they're going to have to pay for it. If it's a delay that nobody really could prevent, well, then, everybody's going to have to deal with it. The owner's going to get it later, and the contractor's going to be, have to be out there longer, but they all have skin in the game. And oftentimes you'll see something like this upstream, and to the extent that you're aware of that, is you're pricing something and signing your own subcontract, you can make the argument, well, this provision applies to me too, and it's a way to try and get around that provision that I just showed you. Now, as you go further into a Turner subcontract, they'll try to limit the recovery for delays. And here it says the subcontractor especially waives and release all claims and recovery for overhead, charges, accelerations, loss of efficiencies. So they try to limit it. Up here, what the language says is, look, all you're going to get from us is what we get from the owner, and if we get it from the owner, it can't be any of these items. So again, it's a way for them to limit their exposure. And there's more ways to limit the exposure. Now, I've been picking on Turner. I've been picking on Whiting Turner. Here's a provision that's come from me. We've all do it, and you can see here, to the extent the subcontractor is delayed, the exclusive measure of damages shall be overtime. So there's ways that like I said, in these subcontracts where they can really try to limit the delay and the acceleration costs, which can be quite extensive on a large project. Your loss of productivity can be very high, and your overtime costs aren't going to cover that.
And like one question came in, going back to your prior slide, by owner, could that also mean the architects or project management team?
The argument the way I would look at that is the owner is responsible for the architect, the owner is responsible for their people. So whether it's the owner or his architect or somebody else that the owner hired, to me, it's the owner. So the point that I wanted to raise here is, look, you have these nasty provisions, but I think it's important for a trade contractor to put the CM in a position so that they can get the money from the owner. Help me, help you. And you do that by providing, you're providing timely information to the CM as you're pricing things. Make sure that they're priced accurately, that you're bringing issues to the table so that CM can inform the owner and protect the entire project team. So if you see the project going off the rails, it's best to have this discussion early on and deal with it and try to get that CM to realize it and talk to the owner and make sure the owner understands it, because that's really the best way to deal with the delay, is for everybody to work together and for the CM to present it to the owner and get that recovery early on. So next, we want to talk about design obligations. And this is a provision here from Hansel Phelps. And you'll see this throughout is it says it's only applicable if the work includes design services. And when I'm asked to review a subcontract, I'll see that and I'll be like, hey, we don't think there's design services. There aren't any design services. What are the design services? And you get crickets. They won't tell you what the design services are, but they also won't strike it. So either we have design services or we don't. But for whatever reasons, I have a very hard time getting them to strike this when someone's just doing it straight from the plans and specifications. But you'll go further into the agreement, and it defines design services to be delegated design services, design assist services, design build services, and design assist. Well, those are terms that everybody uses, but there's a lot of confusion about it, and the courts haven't really settled in on it. When it comes to delegated design and design assist, I don't believe there's no universal agreement on terms. The AIA published something back in 2020 that talked about it. I think it's a good guide. And when it comes to design assist, you can see how they describe it. And as I see it, it really relates to pre-construction services to help help guide the design to fit the budget. Whereas with delegated design, the design responsibilities are established by performance specification and then prepared by a design professional. So I think with a lot of people on this call, that would be, okay, we have a framing design for the exterior of the building. It's supposed to handle these type of loads, do this or this. It's up to you, framing subcontractor, to design it from there, and you hire your design professional to take it from there. But the key with that is those initial requirements, that should still be on the designer of record, the architect of record. That shouldn't be shifted on to the person that's essentially preparing the shop drawings. If they were told to satisfy these requirements, they shouldn't have to take responsibility for those requirements if they're proven wrong. So ways to limit your exposure, and this is what I was just saying: the contractor shall not be responsible for the adequacy of such performance and design criteria. So if somebody's has given out faulty performance or design criteria, that responsibility should stay with them. And then here's language that I've used in other instances where talks about the design services being provided. It'll culminate with stamped shop drawings. But the project architect shall retain overall responsibility for the design, and it's going to stay with them. And then the other element that I like to have is look, the framing subcontractor's liability for such design services shall be limited to the extent of its professional liability insurance or what it can get from its consultant. So in that instance, you're covered by insurance. You try to get that so that you're limiting your exposure for what you have insured. And then with regards to design build,
I'm sorry. I think that just to add on here is there is a lot that in terms of your exposure with your insurance, right, and what you are accepting or not accepting. But there's also a lot of dollars, and your example was perfect. When you have an exterior condition, and I've had the debate often with folks, even engineers, structural engineers, about, hey, you go to the effort of gauging a drawing, and then you put the liability on us to come up with the design criteria and basically have our own independent stamp, which we'll subcontract off to an engineer. But it adds a lot of confusion. Because you'll have documents that have a specific gauging or detail, yet we hold the liability. And then if they don't offer that detail, their argument is if I don't offer that detail, then I don't have comprehensive bids. So this is an ongoing conversation, and I don't know that one size fits all. It's just, as you are trying to note here, is really understanding what conditions you're working under, right? And what assumptions are being made and what you're going to be held to contractually. And I really do like the language that you have in here for basically a cap, that I'm not going to go beyond my insurance liabilities, my professional liabilities, and those types of things. And those are the types of things and exposures you want to review with your insurance company as well. So sorry to interrupt, but I think it's a really valid point. I know this is a confusing area for contractors.
And I think that's the trend, is to try to shift as much of the design downstream, and we're going to continue to see that. And on one hand, it allows a framing contractor to be brought in early on in initial, design development. On the other hand, it does present some more risks because they are involved as the design is starting to come together.
Well, and in talking to the engineering community, I have a friend that's a structural engineer, and he's like, I can't tell you what you guys want, because if I do it one way, you'll want it one way. And he goes, I can't win. And it's so confusing even for engineers to really help lend in, because it's just muddy. To what degree do they design to, and what value do we think we want to bring to the table? And of course,
Right.
we would say, well, just design it all and we'll price it accordingly. The double-edged sword of that is then we also go into our clients and say, hey, bring us on early because we think we can add value and help you engineer this and get it to a price point. So we're in conflict as well with our messaging of what we want to value, what we want to be, and be at the, at the table early and be in those conversations. Yet we're muddying the water ourselves.
Right. So when it comes to design build, that's where you have responsibility for everything, and you're responsible for both the construction and the design. So, if you're the owner, you only have one throat to grab. You don't have to go grab your architect or your CM. You just have one responsible party, and there's no shifting of the overall project design. So you don't have these compartments that we just talked about that you may have with design assist or delegated design. The design builder has it all. So, as I talked about, especially with design assist and being involved early on in a project, even though you may just be providing pricing, that could be construed as being design. So I encourage you to talk with your insurance professional. If you don't have professional liability insurance, I encourage you to look into it, only because as we're seeing, more and more trade contractors getting involved earlier in the process, my concern is that at some point in time, somebody's going to say, well, you were doing design work, and if you don't have insurance for it, that makes it harder to deal with. And the other reason why is you're having these evolving technologies. You've got the layout machines, you've got BIM. You're seeing more and more, more and more applications where somebody's needing involved with the design. And again, I encourage you to work with your insurance agent, update them on what you're doing. If you're using these new technologies, let them know that there's cyber security and building information insurance that you can get. I encourage everybody to study that and talk with their insurance agents, because like I said, these evolving technologies, I think are bringing in different aspects that people may not otherwise have appreciated. But I mean, think about it. If this layout machine, does it wrong, who's going to cover that? How does that work? It'll probably be very difficult to put it on, the manufacturer of this. Whoever was responsible for bringing it out on the project is going to be the initial person that's going to be looked to have responsibility for it. So again, I encourage you to look to see to check out your insurance program and make sure you're keeping your insurance agent up to date. So when it comes to claims and dispute resolution, the key provision is, as I see it, is the notice provision. To stay in any kind of claim, it's very important to provide notice. I mentioned earlier that Ohio has a favorable law on delays. The no damage for delays aren't enforceable. That's good for Ohio. What's not good for Ohio is they strictly enforce these notice requirements. So if you don't provide the notice the way it's written in the contract, you're going to have a difficult time getting your claim through. You can't just say, well, everybody talked about it, everybody knew it. That's probably the case. If there is no written notice within the time period that's talked about in the subcontract or the contract provision you're operating under, there are cases here in Ohio that nullify the claim. So here in Ohio, or I'm sorry, here with this AIA document, it talks about 21 days after the occurrence to provide a notice of a claim. It also says in the AIA documents before proceeding with the work. The point here is the earlier the better. And obviously, if you can do it before you're doing the work, that's the best approach. But when you go and you look at Turner, they have within 48 hours. So you have some very tight time frames. And what I encourage you to do is when you're writing these notice provisions, make sure you know what that requirement is, and make sure that you're submitting the notice within that requirement. There may be times where you don't exactly you didn't know really what was happening until it happened to you. You may have guessed that it was going to happen. You had a pretty good likelihood, but it wasn't until, okay, now I'm seeing the rain come in because the roof isn't here, and now I can't do the framing, or I can't do the drywall. So I would say in that situation, you can provide your notice and provide it within the time period that's in the contract. But what you don't want to do is say, well, we've known about this for 3 months, and now we're finally just getting around to provide the notice. If that's the case, someone's going to say, well, you agreed to provide it much sooner than that. Now, oftentimes they'll have a provision like Turner does here. We talked about the 48 hours, but if it's in variance with what's in the general contract, the general contract is going to control. So again, it's important to get that general contract and see what notice provisions there are there, because you probably have something that's a little bit longer. So when do you provide notice? That's hard to say, but I gave 8 examples here. You can see, if you're not able to start when you were supposed to. There's delays to other trades, such as the building roof isn't in, the building's not enclosed. There's not enough information being provided. You're losing your production window. There could be a change in the project team. Maybe the architect or CM is fired. There could be an accident or weather event that's going to push out the project. Or there's a request to proceed with additional work. You'll obviously have the added scope work that comes with that, and then you may have the added time, or you may encounter a condition that's contrary to your scope of work. Maybe there was a smooth flow to how it was represented in the schedule, and now all of a sudden everything's getting stacked on top of each other. And then the other one that I bolded is you received a no-cost time extension change order. Oftentimes, that's an indication of, hey, look, there's been a delay to the project. It's not your fault. They're asking you to agree to the extension at no cost. Maybe that's what you want to do, but I would evaluate that, because to me that signifies that you're going to be out on the project longer for reasons that weren't your fault. Otherwise, they would have blamed you. They would have assessed you with liquidated damages. But here they're saying, no, we'll give you the project extension. We just don't want to have to pay for it. In those situations, I would evaluate that. And if you think you're entitled, or this is going to be additional cost, I would think twice about signing that.
And Mike, we do have another question coming in. This one is, can an email discussion be notification, or does it need to be a formal letter?
It needs to be a formal letter. It's best to be a formal letter. There's been instances where, like, it's in a daily report, maybe it's in a meeting minute. That's not going to count. To me, I would feel more comfortable if it's in a full-blown letter. How best to provide the notice? As I indicated earlier, it's better the earlier provided. Written notice, like I said, a formal, a full-blown letter versus just a a cryptic text or an email, because someone's going to say, well, those happen all the time, and just because somebody puts in an email doesn't mean it's going to bubble up. Well, it's bubbled up when it's in a formal letter. You state your damages as early as you can, and then you have the project documentation, pictures, things like that that support that you're working in an inefficient or a manner that you couldn't have priced. Now, when you provide your notice, avoid the temptation to throw someone under the bus, especially at this early stage. Oftentimes, a trade contractor will be very frustrated with the CM, and I understand that. They're losing money. It's very inefficient. The crews are frustrated, and there's a natural desire to want to blame somebody, and it could very well, in fact, be the CM. The problem you have is that oftentimes, with where the trade contractor sits at that point in time, they don't know what's going on upstream with the CM and the owner. They don't know what's going on with the architect. They don't necessarily know what's going on with the other trade contractors, and there may be a reason why the impact that the trade contractors experience. There may be an explanation for that it's not the CM's fault. And if you blame the CM, then you're putting all your eggs in one basket. To me, I like to take the approach, just focus on the activities in the events, and then wait to see how it plays out before you pick a lane. Because if you throw the CM under the bus, when in fact it's the owner's problem, the CM is not going to have any incentive to want to help you. If you're bad mouthing the CM in an instance where it's probably the owner that's more at fault, you're just shooting yourself in the foot. I don't know if you've got any perspective on that, Shawn. The dynamic that you play with the CM and an owner.
Yeah, actually, I wrote down here earlier just to make the note that this can be an opportunity. A lot of times we do repeat work with clients that we build relationships with, and there's no reason to destroy a relationship over one particular challenge. So I would be upset with my team if they were sending out notices and contractual notices and not picking up the phone, not having conversations, saying, hey, and just understand I'm trying to protect us, you and me, and I'm going to document some things. It's going to come your way. We can walk our way and we can talk our way through this. This may be information that you can share with other parties, such as the owner, because we're at this spot where we need to work through some challenges. But hey, and that goes with all of this, whether it's a conflict or something like this, or it could be non-payment or whatever. It's just try to keep the emotion out of it, try to be matter of fact, and try to be solutions based, and you'll go a long ways. Been doing it for 30 years. I can't tell you how many contracts we've entered into and I've overseen, but I've been to arbitration twice and court 0. And so it's just a matter of listening, helping each other out. They don't want to be in the same situation. So 99% of the time, you can work your way through those. And it's just Mike did a great job here, just like treat each other like human beings and work through the challenge. They know they have a challenge, so work through it as a partner versus adding a lot of conflict and emotion to the situation.
Yeah, I think the comment about calling up your person on the other side before you send the letter to let them know it's coming so that they can inform their leadership. I think that's always a good idea. That's always a good rule of thumb. And you agree to disagree, but professionally we're going to treat each other right.
Yeah, I mean, we use these as tools as well, right? So if there's some avenues that we can help say, hey, we want to provide you consistent feedback on what we're seeing as some pinch points or some things in the critical path that might be an obstruction coming up. We know, let me help you help yourself. And we're not providing this information as a gotcha. We're providing this to help the project be a success for all of us. And usually that conversation goes a long way.
In most instances, when you provide notice that you're being impacted, you'll want to request an extension of time. Even if they don't grant it, and oftentimes they don't, at least then you can say, hey, look, I requested an extension of time. I told you it was going to finish longer. And as a result, you denied that. And as a result of that, I suffered compression. I had to accelerate, but I gave you that option to extend the project time. When you're going down this path, in most instances, you're going to have to provide your job cost report at some point in time in your estimate. So just keep that in mind. If you delay that, it's going to make as though that you've got something to hide, and in my experience, this is going to prolong the inevitable. So I always encourage people to be willing to provide that. You can do it in a way that keeps it confidential, so it's not on the street. But in most instances, a job cost report is going to be requested along with your estimate to analyze, what you expected versus what you've actually encountered. So you've provided notice, you've done all of that. Just be careful about signing change orders, schedule sign-offs, or anything like that where you could waive your claim later on in the project. What do I mean by that? You can see here, through the acceptance of this change order, the contractor acknowledges that it's reviewed the progress of the work. And as a result, this change order includes a compensation to the contractor for any and all effects. And the contractor recognizes there's no basis for any such claim in the future. So when you're signing that change order based on that, the argument's going to be, hey, up to this point in time, you've released everything. And that's probably not going to be the case when you've taken the time, to provide notices about the overall project, and you're being asked to sign a change order here that may be about adding some doors, which, obviously doesn't relate to the overall project and the notice that you were providing. Same thing about progress waivers. You can see them baked in there. Be careful when reviewing those, when you're in this mode of a project where you've provided notice and you're in this claim mode. And then when it comes to the legal process, it's generally 18 to 24 months from a time a lawsuit is filed or an arbitration hearing is conducted. During that period of time, it's going to be like you're working on a project that you're not able to bill for. Your project manager is going to have to deal with the attorneys. You're going to have to deal with the attorneys. And yet it's a project that you can't submit a bill for. So it's like a diversion from your core business. So if you want to go down that path, you just have to keep in mind that in some ways you're shorthanded on your profit generating core business. Now, litigation versus arbitration, I like to use the analogy of beer. Because, with Bud Light and Budweiser, they both taste like beer. When it comes to litigation, arbitration, they're both expensive. With litigation, it's a courthouse setting. It's going to be decided by a judge or jury. With arbitration, it's private. It's going to be in a conference room. It's going to be decided by a panel of industry experts or attorneys. The discovery in litigation is essentially full blown. It's extensive, whereas arbitration, it's supposed to be limited depending on your panel. It'll depend on what they think. With litigation, there's going to be an appeal. So even if you're successful on a trial, you can expect appeal to take place, which is probably 6 months. So again, it extends the time, whereas with arbitration, there is no appeal. And in general, it's less formal than litigation, but they're both expensive. I would say arbitration is supposed to be less, and that's probably what I would tell you, but they're both expensive at the end of the day. Don't think that one is going to be is significantly less. When it comes to construction claims, like I said, they're both expensive, but in the post-COVID era, arbitration is typically quicker. Courts have always been backed up, and they're even more backed up now. And it's been that way since COVID. So if you're the party that's going to be chasing the money, which is probably most people on this call, to me, I would recommend trying to go to arbitration because I think it's quicker.
And Mike and Shawn, we do have one question that came in. Shawn, this one's geared a little bit more towards you. Can you elaborate a little bit more on your previous "we will come to terms" language being added to proposals? Is it as simple as adding that line to gain protection that you're going for?
Yeah, I mean, it gives you an avenue on your proposal to revisit your proposal if you can't come to terms in the future. Sometimes they will have in the contract documents, you know, with the drawings and all that, they will have the contract and they will notate in the proposal documentation that upon pricing this, you agree to the terms of the contract. Well, we probably don't want to do that. So we will stipulate in those proposals that no, we have the opportunity to negotiate terms and conditions, even if that's in there, so that becomes a talking point as we go. And maybe we're doing a post-bid review and an interview on that job. It is part of our talking points when we're walking through our proposal, saying, hey, we reserve the right to negotiate language on this project before we just, you know, agree to it because it's a part of the construction documents for bid. And I hope that makes sense to the person that asked that question. And it's also just, it leaves the avenue that later on, when you have time and you're at a price point where we're talking about a job, if there's conditions that you think cost you money, whether it's additional insurance, whether it's just because there's more risk, I have the opportunity to price that in, or we can negotiate the terms of the contract or an agreement to a better understanding.
And thank you, Shawn. They did confirm that makes sense. So thank you.
Yep.
I've seen people condition, you know, have language in their bids that says this bid is conditioned on a mutually agreeable subcontract, such as consensus stocks or AIA 401 unmodified. You can just have that blurb, and that's another way, you know, so that you're not getting pinned when you get a subcontract that obviously is going to have far different terms. So one of the other issues that we're seeing is supply chain problems, and and I talked about this concept of litigation and arbitration. And here, with the supply chain, you see the way the contracts oftentimes are worked. Got the owner above the contractor, the subcontractor, and then the local supplier and manufacturer. A lot of times what you'll see is, okay, we got litigation in two of them, but then there's arbitration in the third. And what that means is the subcontractor is out on an island. So if there's a dispute about, the material or something like that came out to the project, the subcontractor is responsible for that. But that subcontractor can't bring in the manufacturer because there's arbitration in that and their agreement, whereas the agreement's upstream or litigation. So that puts the subcontractor, like I said, on an island where they have to almost defend the manufacturer. So we always like to see consistency. It could be arbitration all the way through, or it could be litigation, but if you can't bring the person in downstream, that's an exposure for you. The other supply chain problems that we're seeing is there could be limitation of risks in the agreements you sign downstream with your manufacturer. There could be language in there. There's no liability for delays. There's waivers here for consequential and indirect damages. That's not so bad, but what can be a problem is in no event will company's liability in connection with the provisions or products or service or otherwise, provided under this agreement exceed the entire amount paid. So, in this situation, you could be providing, the door supplier, may have $100,000 in doors, but if that supplier is late, getting material out to the project and you can't get a CFO, well, then you could be assessed for liquidated damages far in excess of that $100,000, and then you're stuck in the middle. So things to keep in mind as you're signing up your different suppliers. So ways you want to deal with that: disputes should be resolved as required in the subcontractor's agreement with the CM. That's what I talked about, so that you don't have this difference between litigation and arbitration. The supplier is required to provide the product in compliance with the project plans and specifications. So basically you want to say whatever requirement I have to meet in the specs, it's going to funnel down to that manufacturer so that you can just look to them. And the same thing with the warranties. They're supposed to provide the same type of warranties. And then to the extent that there's conflicting terms with any of the documents, the terms of your purchase order, the subcontractor's purchase order is going to control. Ideally, that's what you like to see. So we've covered a lot of ground. I can stay on for any questions, or if somebody wants to email Anne-Marie or myself, I can provide my information. But I appreciate everybody's time.
And we do have one final question that came in. Do you have any tips on requesting the upstream contract? They don't do it often.
Yeah, the way I would do it is oftentimes in your agreement, in the beginning of it, it says this agreement consists of the prime contract and the general conditions, and you are obligated to it. And my argument would be, well, I need to see that if I'm obligated to it. And oftentimes it says in there, it'll be provided upon written request. But to me, if you see in there that you're obligated to have to comply with the prime contract, you have a right to see what that prime contract says, and they can redact it and take out the financial information. You don't need to see the markup or fee or things like that, but we do need to see the terms, because that's what's going to get passed down to us.
All right. Well, it looks like we answered all the questions as they were coming in. So thank you, everyone, for joining us on the webinar, especially Mike and Shawn. Thank you for your time today, sharing your experiences and knowledge. Looks like it was well received. So thank you again, and we'll catch everyone on the next webinar.
Thank you. Thanks,
Thank you.
Mike.
Thanks, Shawn.